to Crime in Court. This is the Canton Cover Up series, and we are on episode 93, Big Wins for Turtleboy in Court. So, obviously, we are talking about the Commonwealth versus Karen Reed, and that by association means also the Commonwealth versus Aiden Turtleboy Carney. And as the title says, we are going to talk about the court date that Aiden Carney had today. He was in court this morning. But first, we are going to read through the opposition from the Commonwealth regarding this turning over of Michael Morrissey, DA Michael Morrissey's email, his private burner email that he was caught, totally busted, doing some business on. So, for that reason, and talking to judges ex parte, big no no. So, yeah, so let's get through their opposition first. It's about 11 pages, so it's not short, but it's not long. So we'll get through that, and then we will watch the trial, the hearing that took place today with Aiden, and we will see Mark Betterow and Tim Bradle in court defending Aiden, which is great to see, and kind of weird to see Mark Betterow in the courtroom, but very good. All right, so let's read through this real quick. So we've got the Commonwealth versus Aiden Timothy Carney, Commonwealth's opposition to the defendant's motion to compel Rule 14 discovery and for issuance of a Rule 17 summons. Introduction. The defendant, Aiden Carney, has moved this court to authorize a Mass R. Crim P. Rule 17 summons to Cellco Partnership DBA Verizon Wireless. So doing business as Verizon, they want Verizon Wireless, their records, for any and all emails or text messages sent or received beginning on April 10th, 2023 to the present associated with the present individual associated with the Apple iPhone and or iCloud account assigned to private subscriber Michael Morrissey. To retain the resultant production of records under impoundment, which just means that they're under seal, to appoint a special master, footnote omitted, independent from, but at the expense of the Norfolk County District Attorney to review the content and provide to the parties all Rule 14 discoverable statements between and among the subscriber and any civilian witnesses or law enforcement witnesses or alleged victims, and any ex parte statements to the judiciary concerning the defendant herein or any other witness or person connected to the defense of the above captioned cases or the pending case in the Denham District Court involving the same complainant. Alrighty. Excuse me, that thing's not supposed to make noise. All right, yoked to the defendant's breathtakingly broad Rule 17 motion, accompanied by a novel reverse taint team procedure in a purported Rule 14 motion directed at District Attorney Morrissey personally, largely duplicative of the avalanche of discovery demands and motions, some meritorious, some not, previously advanced by the defense. The present defense motion is utterly frivolous, designed to retard the progress of the case, and unworthy of this court's consideration and time. The Commonwealth opposes the motion and asks this court to deny it. The Rule 17 motion and associated requests. The purported basis for the defendant's Rule 17 request is what he deems an ex parte communication to the presiding judge sitting on Mr. Carney's case attributing negative conduct to Mr. Carney on private email. Well, yes, he was doing that. It's not alleged or I don't know, purported. Um, Characterizing this as a knowing and willful violation, the defendant suggests it begs the question will equally whether there were equally discoverable responses from the judiciary, and if so, did Morrissey cover them or delete them? That's a good point. So, did any of the judges that Morrissey talked to write back? The Commonwealth cannot but applaud the defendant's restraint in forbearing. Let me start this sentence over. I don't know why my brain says the wrong thing. See, this is what I just did a longer stream a few minutes ago, like a recording a few minutes ago, and now like my brain and my tongue get tired. So apologies. The Commonwealth cannot but applaud the defendant's restraint in forbearing from asking this court to issue Rule 17 subpoenas for any and all emails and text messages sent or received by those members of the judiciary who were sent the district attorney's alleged ex parte communication, perhaps grist for a future discovery motion. Uh, where did I leave off? All right, so he adds that the other obvious issue raised is whether there are other discoverable communications memorialized and hidden away on his personal devices. With the begged question and the obvious issue, the defendant clearly flags that he is improperly advancing a discovery motion cloaked in the garb of Rule 17 motion, a point that the Commonwealth shall develop at greater length below. So, huh. It's an interesting argument that they're improperly advancing a discovery motion, which they're cloaking as a Rule 17 motion. All right, so what happened was this. A witness in the Karen Reed case, having been victimized by the defendant's online harassment, sought a civil harassment prevention order pursuant to GLC 258E in the Stoughton District Court. Personnel from the Norfolk District Attorney's Office provided standard and entirely conventional assistance to the witness in preparing and filing the necessary paperwork. Present in the room when the paperwork was filed, though not playing any official role in the receipt and handling of the application, was the clerk's office personnel member, later identified by District Attorney Morrissey. Remember, this poor woman, whoever they were, worked at the DA's office in some fashion, and somehow they found out she was like a follower of Turtleboy on social media, and therefore they believed her to have been leaking public information to Turtleboy. So even if she did give this information to him, there's nothing wrong with that because it's public documents that are available to anyone. Yet somehow it makes it a fireable offense. So, on information and belief, this individual was well known among her colleagues as an admirer of the defendant's propaganda efforts on behalf of Karen Reed. So, this is all just propaganda. Everything coming from my mouth, the mouths of all the other Karen Reed supporters, anyone who's looked at the evidence and believes that Karen Reed is innocent. We're all just spewing propaganda according to the Commonwealth. According to, is this Brennan? Let me see who wrote this. Oh, Robert Cosgrove, right. We're on Turtleboy's case. So Robert Cosgrove, the special prosecutor Ken Mello was the special prosecutor assigned. He's been on medical leave or something forever once we found out that he was colluding with some other individuals to get Turtleboy put in prison. Um, yeah, he's kind of been MIA. So this Robert Cosgrove has stepped in. So he's the one that wrote this motion, apparently. All right, so in due course, the hearing went forward as is typical for an anti harassment proceeding. The initial application was considered ex parte, and thus Mr. Carney was not notified and was not present. If an order is granted ex parte, it expires within days, and the responding party is summoned in for a hearing on whether the order shall be extended on a long term basis. What are they talking about? An anti-typical it as is typical for an anti-harassment proceeding, the initial application was considered ex parte. Thus, Carney was not notified and was not present. That does not no. They're trying to say because this was just an initial conversation to get the initial application for a restraining order, because it was just in the initial process of that application process, then it's okay for Michael Morrissey to contact judges on a one-on-one basis or one on however many he sent at the same time. But you get what I mean. Like he shouldn't have been having private conversations with judges about Carney's case. But that's their argument that he didn't need to be present because this was just an initial application part of the process that, just typical random everyday stuff like this happens every day. Whatever. All right, so if an order is granted ex parte, it expires within days and the responding party is summoned in for a hearing on whether the order shall be extended on a long-term basis. That's if the anti-harassment, the RO, the restraining order, that's if that is granted. But that's not what we're talking about here. And still, the judge should, or the DA shouldn't have been talking to the judges about it. The judge presiding at such a hearing considers the entire matter on a de novo basis without reference to the ex parte hearing or order. In this instance, the application was denied in the initial ex parte stage, and there was then nothing before the court. After the denial, and thus the termination of the case, the district attorney sent the communication appended to the defense motion to the Chief Justice of the District Court and various others, including Judge O'Malley. It is notable what that communication did not do. It raised no issue concerning any active case before the court. It did not complain about the outcome of the then concluded hearing or ask that Judge O'Malley reconsider the motion or that a different judge other than O'Malley hear it. It did not suggest that Judge O'Malley had acted improperly or so much as hint that the district attorney would encourage the applicant to appeal the denial of the order. It did not talk about any active criminal or civil case involving the defendant. It did not even suggest that Mr. Carney had acted improperly, but only made the factual observation that he was the recipient of an improper leak. In short, it was not an improper ex parte communication in any accepted sense of the term. He's just blowing smoke up our skirts because um this is not, no, this is all just, well, it wasn't this and it wasn't that. And you can't say that he was talking. No, he was definitely talking about a restraining order against Aiden Carney and the fact that these judges needed to do something about it. And he needed to have more confidence in the system. And yeah, there was definitely some implied things going on in his email. Wonder if I can bring it up. Hold on one second. Let me see if I can find it real quick. All right, sorry. I wanted to show you, whoops. Hold on one second. I didn't put it into a PDF. One sec. Okay, now I'm ready, I think. So this is Morrissey's email to the judges. So backtrack slightly further. So a couple of the Alberts, Colin and Chris, as well as John McCabe, tried to get restraining orders on Turtleboy. They were all denied because everything that Turtle Boy has been doing is it all falls under free speech. So they had no authority to do anything. Well, then they go and they find this witness intimidation statute and decide, oh, we can get him on that because all it says is like emotional harm is all that's needed to be caused. And congratulations, you've upset a witness and thereby you're intimidating them or something. But really, all Turtle Boy is doing is trying to convey the facts of the case. And if that's threatening to Colin, Chris, and Jen, well, then that's something completely different than witness intimidation. So, yeah. And witness intimidation is like, hey, you better not testify against me or I'll hurt your family. That's witness intimidation. But trying to uncover the facts of a case and just following the facts of a case, that's not witness intimidation. So, anyways, the um this was his response. So after Chris was denied his restraining order, Jen McCabe sent a text to somebody saying like she was horrified that Chris didn't get it and blah blah blah. And then she was mad that Turtle Boy got the documents. And that somehow was, I don't know if that was directly sent to Morrissey or if that was sent to someone and then sent to Morrissey. However, it became in Morrissey's possession, and due to that, he sent this email out to multiple judges, multiple individuals that he should not have been having an ex parte or a one sided communication with. So here's what he says, and this is regarding the Turtle Boy issue. So, dear Judge Fuentes, that's Fortes, sorry, Stacy Fortes, I am writing to express my grave concern with actions taken by an individual employed at the Stoughton District in regard to an affidavit that was shared with a blogger writing about an ongoing second-degree homicide case on 9/28/23, a witness in the Commonwealth versus Reed, look how he spelled Reed here, REED, homicide case. Notice he spelled it wrong because in a FOIA request, if you are searching for Karen Reed and you spell it the correct way, you're not going to get this email in your search results. So that's kind of a big deal. And all other spellings that might be confused with READ, I think, should also be searched. Anyways, so on 9/28/23, a witness in the Commonwealth versus Reed homicide case filed a request for an application for harassment prevention order, which was heard before Judge O'Malley. The application and affidavit were processed in the Civil Clerk Department of Stoughton District Court and presented to the judge, which, after hearing, was denied. So the judge heard everything in this case, everything regarding Chris Albert's um, complaint against Turtle Boy and was totally denied. So there's that. We were informed by the witness and others that shortly after the hearing that Aiden Carney, aka Turtle Boy, was provided with a copy of the entire affidavit. Again, even if he was provided with this, even though he could just go to the court and get it himself, um, the stuff is public. It's not hurting anyone that he has this. The only thing that's hurting Chris Albert is Chris Albert's pride because Turtle Boy is pretty ruthless when he thinks you are covering up for cop KI double Lers. He's pretty ruthless. So that's the only thing that's threatened is Chris's ego and his freedom and his son's freedom too. All right, so there was no way that he could have been aware of the proceeding without an insider working in the courthouse. This is the whole insider working in the courthouse thing. The individual who presents as a possible leak. Not even they haven't even confirmed that she did anything yet, but they say it's a possible leak by this woman, Michelle Littlefield. And they did, in fact, fire her for this instance, whatever this instance is. They don't even have proof. They said it's a possible leak. They fired her. Somehow she got a copy of some communication from Michael Morrissey's iCloud email, because as you can see, this is his iCloud account here, and not his Norfolk District Attorney email. So Turtleboy gets a copy of this iCloud email and says, "Hey, Michael Morrissey is doing business on his private email, private email server so that it doesn't get FOIA'd." As you can see, he really went to great lengths not to get FOIA'd. Misspellings and all of those kinds of things. All right, so rather, the obvious and entire thrust of the district attorney's communication was his concern that leaks from the court clerk's office erode the trust and integrity between the courts and the public, and his concern that such conduct would be repeated, that the Stoughton District Court might in the future handle ongoing motions or other requests for warrants that, if leaked unsolicited to the third party, would affect the orderly and fair administration of justice. That's not what it really sounds like to me, but okay. It There was more to this, I believe. Did I miss it? I don't know. Um, I could have sworn there was something else that comes to mind, and now I can't remember. Forget it. All right. So, moving on. This observation was simply cold truth, but even if it were not so, it was an entirely appropriate communication. So he's saying there's nothing wrong with this communication, although I beg to differ. They're saying like witnesses. I could have sworn he said something about it's eroding the trust in the justice system. Maybe there is more to this. Hold on one second. Let me just double check because this is gonna bother me. All right. Sorry about that. Um, I knew I wasn't just making it up out of thin air. All right, so this is, I guess, a second part to the email or a different part of the email. It goes on, although we're missing a portion of it. But it says, it's clear from the postings that Stoughton Court is directly involved in this dissemination of information affecting our prosecution. So he had posts from Turtleboy that he provided, I think, and that's where that gets cut off. All right, from the comments from one of the witnesses, you can see that they have completely lost all confidence in the courts of the Commonwealth. That's what I was talking about. This is the comment from John McCabe, like the Turtle Boy got it again, got the affidavit again, like right away. So she was mad about it. And so here he's saying that they've completely lost all confidence in the courts. I have to agree that the actions erode the trust and integrity between the courts and the public and the relationship with the DA's office. So he's agreeing. He's creating a stance or taking a stance, and he's saying, I agree with this, and I don't think that this is right, and I don't think Turtle Boy should, whatever. They really hate Turtle Boy. They have Turtle Boy derangement syndrome. All right, so we are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage to witnesses in an ongoing homicide prosecution, must be a violation of court policies or a potential violation of law. Improperly disseminated court material unsolicited to a third party. How do you know it was unsolicited? How do you know he didn't already know that there was some hearing that was taking place about him, about Chris Albert trying to get this restraining order on him? This is very He says a lot of things that you can't really back up. Where did they leave off? We also understand that Aidan Carney had also immediately requested copies of the FTR record that was made on 9/28/23. Again, there is no way that he would have or should have known that that hearing took place. Well, how do you know that he doesn't know? How do you know that he isn't diligently on top of things, on top of the docket, on top of, the cases that are coming in? This is kind of what he does. I mean, you can't say that he shouldn't have known or would have never known. And even if someone did tip him off on the inside, who the hell cares? It's public record, public knowledge, public courts. Why are we trying to hide it? Why is it not okay that Aiden knows that somebody was trying to get a restraining order on him? Shouldn't he know that? Kind of important. There are a number of concerns that we have about the possibility of having filing ongoing motions or other requests for warrants before this court that will affect the orderly and fair administration of justice. These actions are completely unacceptable. So he's saying by not doing anything or, not going further and not making something happen in this case is unacceptable. He thinks that, there needs to be warrant requests or whatever. I understand that you do have an investigation and that may take time, but you also have to provide us, telling the judge, you have to provide us with evidence and assurance that you have taken action so that we can safely continue to use the clerk's office in the Stoughton District Court. We have a number of delicate matters before them on a day-to-day basis. I await your advice. So that is very threatening, very, you better do what I say kind of email. Like, it may not seem as forceful as that, but it really is because he's the DA and he oversees Stoughton, Canton, all of the towns around there in Norfolk County. So he has a big say as to what they do and how they conduct business. So, and if he's telling them, well, you need to get rid of Michelle Littlefield because she's a leak, she's leaking information, which is public information. I don't, I just don't see how that is okay. And if I were Michelle Littlefield, I'd be suing the crap out of them. All right, so the district attorney is the elected advocate of the people and the chief law enforcement officer from the Norfolk district. The Norfolk district attorney is responsible for enforcing the rights of the public where the Commonwealth has an interest or is a party. As the chief elected law enforcement officer, Norfolk County overseeing the criminal justice system, the district attorney has both the right and the duty to bring the attention of the appropriate judicial officers' actions by court employees contrary to law, inappropriate, and harmful to the administration of justice. Moreover, that the leak caused witnesses in the ongoing homicide prosecution to lose all confidence in the courts of the Commonwealth. Well, who gives a crap? I don't have any confidence in the courts of the Commonwealth either. Who gives a crap if they have confidence? That makes me so mad. Certainly a fair conclusion. The defendant's immediate use of the leaked material was to publicly gloat about it and the outcome of the hearing and to further mock the witnesses as part of his campaign of vilification against them as demonstrated by his post in his pseudo not very anonymous Clarence Woods Emerson account because the people who work in Stoughton like me more than him, they sent this humiliating he calls it an affidavit as a joke, an affidavit to me so we would shame him some more. We have put in a request for the court audio, which I believe they eventually did get, and hopefully, with a little luck, we'll have it for a live show on Sunday. It's all there. The acknowledgement that a person or persons who work in the Stoughton District Court leaked the information to the defendant. The smug assertion. How do you know that that somebody leaked it to him? He could have seriously, he could have just asked. It's not that difficult. Like uh, they're assuming so many things. They're making so many assumptions that they're doing these nefarious things when even if Turtleboy and Michelle Littlefield or whoever had some kind of arrangement that, hey, if anything comes along with like a McAlbert or somebody, can you let me know? And they do, that's not really an ethical violation, really, because it's all public record. If they were giving out confidential information, okay, sure, but that's not what was happening here. So I don't get this case. I don't get the Commonwealth at all. They make no sense. So it's all there. The acknowledgement that a person or persons who work in the Stoughton District Court leaked the information to the defendant, the smug assertion that they did so out of bias towards the defendant and or dislike for the applicant, the improper purpose, so we should shame him some more, and the plan to further humiliate him by playing on Carney's live show. Well, who gives a crap? Public, public court proceedings, public record. And no doubt commenting on the audio of an official court proceeding. Oh no, he can't comment on an official court proceeding? This is ridiculous. This motion in itself is ridiculous. Differently put, the defendant took the denial of an anti harassment order against him as both an incentive and a tool to escalate his ongoing attempted intimidation and harassment of witnesses in the pending case. No, he didn't, but he did take a moment to talk about it on his live show because these people are trying to put him in prison, and I think he has every right to. Yeah, I don't think he knew at the time that they were trying to put him in prison, but they definitely have been trying ever since. Although believing the above discussion establishes that the defendant's factual predicate that the defendant's factual predicate for obtaining a Rule 17 order is utterly devoid of merit, the Commonwealth now turns the legal basis for a Rule 17 order. The purpose of the Mass R. Crim P17 rule is to expedite the trial by by providing in sorry, blah, blah, blah. Let me back up. The purpose of the Rule 17 is to expedite the trial by providing the time and place before trial for the inspection of the subpoenaed materials. In citing a motion pursuant Mass R. Crim P17, the court must balance the defendant's right to mount a defense with the Commonwealth's right to prevent unnecessary delay of the trial and unwarranted harassment of witnesses and third parties. To succeed, the moving party must establish good cause by showing 1. That the documents are evidentiary and relevant, 2. That they are not otherwise procurable. Remember this because we're going to be listening to their arguments in court and try to see if you think that the defense meets all these things. It's number 1, that the documents are evidentiary and relevant, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend to unreasonably delay the trial, and 4, that the application is made in good faith and is not intended as a general fishing expedition. So as we know, that is all the criteria for Lampron. You must meet all 4, not 1 out of 4, not 2 out of 4. You must meet all 4 criteria. So the issuance of the Rule 17 summons is reserved to the sound discretion of the judge. The defendant accurately outlines the legal requirements necessary for this court to order a summons and bravely asserts that he has met them, but gives short shrift to any actual showing that he has done so. As noted, the first requirement is a showing that the documents are evidentiary and relevant. Dwyer at 142, an essential what? I don't know. Dwyer at 142, is that a case, I'm assuming? An essential concomitant of which is a showing that such documents exist. Okay, I guess that's the other case the case that they're referring to, but I never see it like that. The defendant has shown some of these things. Rather, the defendant argues that because, or none of these things, the defendant argues that because he has shown that the district attorney complained about misconduct by the court in a concluded case, and because he included a communication from a witness inferably made to someone in his office, but in any case in his possession, one not here hitherto produced. Why is he talks? I can't read this. This is so annoying. Just the way that he words things, this Cosgrove. Um, but in any case, in his possession, one not hitherto produced in Rule 14, that these alleged improprieties logically betoken more of the same. He urges that it is possible there is more out there. It is also possible the moon is made of green cheese, but merely a possibility, even if couched in as likelihood has never been found enough to meet the Lampron. Okay, so that was really poorly worded, but I get what he's saying. He's saying that there's not enough to. He's saying that the defense has not shown enough to basically prove that there could be some kind of improprieties, even though we see him doing business and it's talking about Aiden Carney in this case. But okay. And let me read here the footnote. If the witness's brief expression of distress at the Stoughton District Court clerk's office improprieties and the outcome of the proceeding is a statement within the meaning of Rule 14, it is barely so. Okay. So he urges that it is possible there is more out there. Yes. So there are likely more emails out there of of Michael Morrissey doing business and talking to judges. If he did it once, he might do it again. And anything that any communications that he's had on his private email or phone number, it should be discoverable. Anything that where he's been talking to a witness or anyone in this case related to this case. And Turtleboy, definitely, if he's talking about Turtleboy, that should be discoverable. Unable even to show that the documents he seeks exist, the defendant cannot possibly make a higher showing that they are evidentiary and relevant. Rather, he asks this court to create, at the Commonwealth's expense, a special master to call through of the district personal cell phone documents and turn over whatever the master, in his discretion, deems discoverable. Well, yeah, because they're not going to leave it up to you or Michael Morrissey to do the deciding of what's discoverable. There needs to be somebody who is a third party, not related to the Commonwealth or to Turtleboy, and looking at it objectively because we don't have that now in Massachusetts. That's why they're asking for this special master to do this discovery. So ironically, stricture that potential relevance and conclusory statements regarding relevance are insufficient. One paragraph later, he attempts to justify his motion simply by stating that the statements discovery are sought are potentially exculpatory and reasonably expected to provide evidence. Apparently, Mr. Carney does not grasp that when the Supreme Judicial Court repeatedly says that potential relevance is insufficient, it means that potential evidence is insufficient. Oh, this guy's a master of words, don't you think? Not. As the defendant has failed to satisfy the first requirement of Lampron, his motion should be denied. However, the Commonwealth shall briefly address the remaining requirements, such of which the defendant has failed to meet. As the defendant correctly states, the second requirement imposes on the moving party an affirmative obligation to show that no other source likely exists for the desired records. Consider one example of a probable application or applicable source. Generally, any communication by the district attorney with a court official regarding matters concerning the court's business is a public record, whether sent by private email or official email. Mr. Carney has not shown that he has first availed himself of this option, although inferably he or his counsel or both are obviously acquainted with the public records law. Got a footnote here. Exhibit C to Mr. Bettero's letter attached to the defendant's motion is a copy of the Commonwealth's contract with Special Prosecutor Kenneth S. Mello. Exhibit D is an internal email exchange of the District Attorney's Office between the second Assistant Krippendorf and Deborah M. Leahy, a fiscal affairs officer, discussing the mechanics of preparing this contract. That these documents were not provided to the defendant in discovery and indeed were not sought in discovery. Rather, they were almost certainly obtained by means of public records request. As of this writing, the district attorney's office has received at least one pseudonym request for the public records that would largely or completely encompass those he imagines exists in the present Rule 17 motion, as well as many others. Undersigned counsel does not attribute that request to the defendant, but neither does he discount the possibility. He simply does not know. Alrighty. Okay. As to the third required showing, that the defendant must show that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And my brain is really freaking tired. It's not processing words right. Apologies. All right, let me start this paragraph over. As to the third required showing, that the defendant must show that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial, Lampron supra, the defendant merely states in a half sentence, prior inspection is necessary for a fair trial. Apparently, he believes that an adequate showing is accomplished by reciting the magic words. Very snarky and kind of rude. Similarly, even though, like, you guys have been caught red-handed, and yet here you are still, like, digging deep, and just, they are denying any kind of being complicit in any of this. They are definitely, conspiring and corrupt, and there's a lot of misconduct going on, but yet here we are turning it around again and like blaming Turtleboy for even asking for these things. It's like, no, Michael Morrissey was hands caught red-handed, because here he is writing and doing business in this personal email, and yet here you are still just fighting it. Just hand it over. That's all you need to do. But they don't want to do that because they're going to have so much on Morrissey once they do. So similarly, he purports to satisfy the fourth requirement by stating that he is not engaged in a general fishing expedition. To the contrary, the defendant's quest is the I'm really struggling. Quintessence. The quest is the quintessence of fishing expeditions. He added that rather, bias and potential bad faith of investigators and their collusion with witnesses for improper purposes is always relevant and admissible. But the fourth requirement is not about relevance and admissibility. Those things go to the first requirement. Moreover, the defendant's purported ex parte communication with the court and the appended comment from the witness upon which he has premised his entire Rule 17 motion do not demonstrate bias by the district attorney. Okay, sure. Have nothing to do with any investigator in the defendant's present case and certainly do not show collusion with witnesses. But we have plenty of other proof that there was, in fact, collusion with witnesses. Brian Tully and Ken Mello. How they both have jobs still, I don't know, but they were definitely colluding with the fake victim and Kate Peter, who is Turtleboy's arch nemesis, and they were trying to get him jailed last Christmas, which I'm scared for Turtleboy like around this time. I'm a little worried for him, if I'm honest. I really, really, really hope that they're not going to try to pull some other crap and get him arrested or put away in on Christmas Day or exactly what they did last year. So finally, whatever the relevance of evidence of bias is a vast oversimplification to say that it is always admissible. It is true that the defendant has a right to present evidence of bias. However, it has long been recognized that the defendant's right to cross-examine a witness is not absolute. As long as the judge does not completely bar inquiry into a relevant subject, he has broad discretion to limit the scope and extent of the inquiry. Moreover, a judge may still determine whether the weight and relevance of the proffered evidence outweighs its prejudicial effect. As the defendant has failed to provide a satisfactory basis for the Rule 17 summons, the court need not reach his novel proposal that the fruits of the proposed search be held by the Norfolk Superior Court Clerk's office and then reviewed by a special master at the expense of the district attorney to go through over a year of communications on any matter whatsoever and attempt to extract the Rule 14 discoverable statements which the defendant posits must exist. Apparently, this scheme is aimed at deflecting the oft expressed concerns of the appellate courts, pointing out the vast amount of data often contained on cellular phones and the potential for invasion of privacy. The potential invasion of privacy is real. Cellular telephones are microcomputers with the capacity to function as a telephone, camera, audio, video recorder, Rolodex, calendar, library, or diary. Modern cell phones have immense storage capacity. 16 gigabytes of storage accommodate millions of pages of text, thousands of photographs, or hundreds of videos. A cell phone may contain financial records, prescriptions, notes, and addresses. Modern application software can collect and manage detailed information about a person's life, including but not limited to medical and financial information, political and religious affiliations, addictions, or substance abuse and reproductive health. So, lots of data can be obtained in an email. Thank you. We needed that laid out for us. It would also have the virtue, from the defendant's point of view at least, of delaying progress of the case toward trial by months at a conservative estimate and forcing the DA to financially subsidize that delay. The Rule 14 motion. As the defendant states, the district attorney is the chief law enforcement officer of Norfolk County and the ultimate authority over all Norfolk County assistant prosecutors, whether designated assistant or special assistant district attorneys. He is not, however, the prosecutor, the pres he is not, however, the prosecutor, the present cases. Okay, this whatever, I'm reading it as it's written on the page. All right, so although it is within the district attorney's power to choose and dismiss prosecutors for the present cases and indeed to try them himself, should he so wish, C. Burlington versus District Attorney of the Northern District, that does not distinguish the defendant's matters from any other criminal case in Norfolk County and hardly justifies personally ordering the district attorney to dance to the tune of the defendant's discovery requests. Rule 14 discovery can and should had, be had through counsel of record upon whom the defendant has hardly been shy in pressing his demands, whether directly or through the court. The present motion smacks less of an honest attempt to procure legitimate discovery than one to provide fresh fodder for the defendant's various internet extravaganzas. So, wait a minute. You think he's just trying to get these emails because he wants to put them on the internet? Even though these emails specifically pertain to him and trying to coerce perhaps some judges into maybe arresting Turtleboy or giving him a restraining order the next time that they go to court. Yeah, that's important to know what they were talking about and what judges responded, how they responded, what they said. Did anybody say, hey, we shouldn't do that? Or did they just go along with it? You know, we need to know that. So this is all very relevant and they're going to get it. So that said, the Commonwealth recognizes its obligations under Mass R. Crim P. 14 and will continue to produce to the defendant any statements of persons the Commonwealth intends to call as witnesses and all exculpatory information, including any material that bears upon truthfulness or could be read as suggesting bias, as well as any material that would question one's credibility or impartiality. This includes communications made by the district attorney. In that respect, the Commonwealth has, on November 26, 2024, provided the Karen Reed defense team with Rule 14 discovery, including copies of various text messages. Many of those involve witnesses in the Karen Reed prosecution, who, by and large, are the alleged victims and witnesses in the prosecution of Mr. Carney. The Commonwealth is prepared to provide the same discovery in the present cases, subject to the same protective orders. The motion should be denied, and that is signed by Robert Cosgrove. Ugh, I hope we don't have to read too many of his motions. They're pretty rough. Pretty rough to read through. All right, so that is the Commonwealth's opposition to this particular motion that we're actually going to watch the motions hearing for. So this is, we're going to swap screens here. So this is the Turtleboy witness intimidation trial. Well, it's a motion hearing, or yeah, the hearing just for this discovery. So they're going to argue the Commonwealth, the thing that we just read, the Commonwealth's opposition. The defense, Turtleboy, is going to argue for his devices back. They still have a bunch of his devices, and they want the Michael Morrissey emails. And that's basically what they argue here. Unfortunately, it was played on live Court TV, and it's only on the Court TV website. So we're going to have to skip through commentary, but here we are. So that's what we have.
On today's Commonwealth versus
I also cannot speed it up. I do have captions on. I cannot
Aiden Carney,
but
23 CR 313, 24 CR 43. Mr. Carney is present along with his attorneys Timothy Bradel and Mark Federer. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for hearing on various motions. If the parties could please identify themselves for the record.
Good morning, Your Honor. Robert Cosgrove for the Commonwealth.
Good morning, Your Honor. Timothy Bradel on behalf of Aiden Carney.
Good morning, Mark Federer from Mr. Carney.
Okay, good morning. First things first, I served with Attorney Cosgrove when he was Judge Cosgrove on this court, and I think this was the only place we overlapped and we were sitting at the same time. I don't think it raises an issue for me, searching my own conscience. I understand that that fact has been disclosed to defense counsel, and defense counsel doesn't have an issue, but I wanted to just flag that and make sure that's correct.
That's correct, Your Honor. We're fine with it.
And does the DA's office have any problem with my presiding?
No, Your Honor.
All right, so that out of the way, tell me what you think we have on the agenda for today. We had it scheduled for an evidentiary hearing on suppression. I was hard pressed reading the papers that I could find a reason for an evidentiary hearing.
You're right, Your Honor. And in light of the recent series of concessions or admissions or stipulations, if you will, of the Commonwealth, we're not proceeding with an evidentiary hearing. We're going to be proceeding with documents from the acknowledged record of the case on the unreasonable delay issue, emails, quotations from the record. I just have exhibits that I would be offering as I argue.
Okay. Not entirely clear to me that I have seen everything. I had a lot of stuff was coming in fast and furious over the weekend, and so I'm not sure I've seen everything. But we'll take it as it comes.
Sure.
Let me just ask in terms of the history of the case, is there now an order for the prosecution of a tainting's review of any kind of electronic data?
No, that's an issue that, I'm sorry, Mr. Bradle.
No, go right ahead. Go right ahead.
That's an issue that I would hope to raise today.
This is Robert Cosgrove for the Commonwealth. He's, I guess, completely replaced Ken Mello. I don't know if he's ever coming back. And this is the best they got.
There's a motion before the court presented by Mr. Bradle to essentially abort that process and return the seized items to the defendant on the grounds that the Commonwealth has unreasonably delayed in following through on the tainting process. So
I just thought I saw something in one of the papers that I reviewed that the issue of a tainting and the procedure that it would follow was submitted to another judge and was considered by, I think, her.
There's been an issue with this case in that they seem to have rotating judges. It seems like every time Turtleboy's in court, there's a different judge presiding over this. So every time you have to give background information and kind of update them on where you are, and the judge has to kind of get briefed and caught up, and it's kind of annoying. And for some reason, Krupp, this is Judge Krupp, who he's been assigned to this case in the past. He's been on this case before, and he seems to be pretty good, and he seems to kind of understand what the Commonwealth is doing here. At least presumably, it seems that way. But for whatever reason, I thought he had to recuse himself because he knew Cosgrove or something, and they allowed it. They were fine with it. And now Krupp is back. Is that the case? I don't know. I feel like I remember that. Somebody brought that up in Melanie Little's chat today, and I think that that's true, that it was Krupp who recused himself off of this case. But why he's back on, I don't know. Or maybe they should ask him to come back on because he's not bad for Turtleboy. But I don't know. I don't know what the case is there with the judges, but I do know that in the past they have been rotating, and he's been getting different judges, and it's really big pain in the butt when you're trying to move forward in your case, and every single time when you're in court, you have to re-explain your case over and over again because the individual that you are trying to argue your case in front of doesn't know anything about your case. And you can kind of see in this that Judge Krupp doesn't seem very prepared. Some people had some different arguments or different thoughts on that, but I don't think he seemed very prepared in this case. He did just say, like, there were a bunch of filings that came in and I didn't get to read them all or whatever. He hasn't caught up on everything. So, but that's not an excuse. Like, that's not right. Like, he should be prepped and ready to go, I think. Anyways, moving on. Let's continue. Hello? Why aren't you working?
Is Judge Rayburn. And I don't know if she, and I think it was even referenced that she took it under advisement. And I didn't want to step on her toes if she had something under advisement in regard to that.
That was my understanding as well, Your Honor, that she took that motion under advisement at the end of the last hearing. That was the last I have heard of it, frankly, and I don't know if she has, in effect, ruled by silence by simply scheduling the hearing on Mr. Bradle's motion to dismiss for unreasonable delay first today, and not acting on the tainting motion, or whether she is still contemplating filing something. I don't know if the clerk has any insight on Judge Rayburn's plans.
Am I contacting Judge Rayburn to find out if she feels like she still has anything under advisement, or if it's still open to this court to reconsider anything or consider anything that she hasn't decided?
None on the Commonwealth's part, although I would ask the court to advise her that in light of some of the filings today, the Commonwealth has filed a superseding suggestion for the tainting process. So much of what she now has, I would say, is probably obsolete.
Judge, my take on it, I have a pretty good memory of this part of it, is that that on that date, council had proffered a motion providing a framework for a tainting. I came in that day and announced to Judge Rayburn that we intended to file a motion to suppress for unreasonable delay, and that I suggested that that should take precedence over ruling on the tainting framework, and she agreed with that. And so
there's an unreasonable delay motion from Aiden and his team because they have had his devices for over a year now. They arrested him last year in October. They've had his devices for now 13, 14 months. And it's time. It's time to give them back. It's time to, put up or shut up. It's time to do it. Like, either go through the and get the files and give them back, give us our devices back, or drop the whole thing and give us our devices back. It's like one or the other. It's like you can't keep them forever indefinitely and never return them. It's not how it should work. I mean, I guess they can. They're the law. They got the gun, so they could do whatever they want, right?
I don't think she's I don't think we're going to get a ruling. I don't think she has anything under advisement. I think she agreed with me that she was going to hold off on that in light of what we're about to do here today, which is the unreasonable delay motion.
Mr. Bradle may well be correct. I would just say that our recollections differ.
Just as a matter of courtesy, I would be in my inclination to call her and make sure that she doesn't feel like she has anything under advisement. Do you have any objection to that?
No, not at all.
Okay, so I'll make that call when I get off.
Thank you.
All right, now, is there a logical order to take up the matters that are
I was going to suggest, Judge, the motion to suppress, and then my brother's going to argue the Rule 17, Rule 14 issues, and then I'll take up any other residual issues we need to talk
Okay,
about.
why don't we deal with the motion? Any objection to that, member?
No, I think that's fine, Your Honor. I have a couple of things I've filed that I would want to address at the conclusion of the defense motions.
Sure.
So, as I said, this is going to be a motion where it's on the documentary record. I have exhibits that I've given to counsel that I'm going to proffer to the court as I go, if I may. And we're going to be relying on basically the documents I'm going to be proffering to the court as exhibits. The docket, if here and there I may refer to dates that are in the docket. For example, there's a May discovery deadline that came and went. I'll refer to that. And then stipulations of counsel, where recently in this last group of filings from the Commonwealth, they stipulated and agreed that Mr. Carney's phones were searched,
Right.
which was kept from us till that acknowledgement. So that's a whole other issue that we want to get into. But I would use that as part
Doesn't
of
seem like it was kept for you because at least Mr. Bettero's letter references it, so you had
Yes.
information about it. Maybe it wasn't disclosed in the Rule 14 process, but it was known to you. But in the event,
Yes,
why don't
there's
you
no
just,
twist.
I don't need to wind up.
Sure.
Get at
Okay.
it.
Sure, absolutely, Your Honor. So, Your Honor, in this case, I came into this case on 10/19, Your Honor, and I immediately sent an email to Special ADA Mella saying that basically, hold on a second here, these phones have all sorts of privileged materials in them. And so I didn't have an exact clear picture of what was in them at that point, but I knew from
There was
time.
no assertion of attorney-client privilege.
Yes, and other privileges too, Your Honor. This is
There was no assertion of attorney-client privilege in October, right?
Initially, I said there was privileged material, knowing that there was source material, journalist source material. The most important thing that I was concerned about right when I came into the case, Your Honor.
All right, we're going to hit the pause button right there. You're not going to miss anything. Straight ahead, more coverage out of Dedham, Massachusetts.
Now I'm going to pause. What is my second screen? Keeps going in and out, flickering. Hold on. Let me get us to the next portion. All right, here we are, back in court.
Which was that these phones had source material given to Mr. Carney from confidential sources, some of which were law enforcement people, about the very same investigators that had seized the phones. So that was the primary concern right at the beginning.
Preventive medicine doesn't deal with that, right?
It doesn't,
Preventive
but
medicine deals with the attorney-client privilege.
Yes, but there's other-
In your initial disclosures or your initial representations, you were not representing that there was attorney-client privilege material on the phones.
right, not on the first day or two when I got the case. I didn't know that yet. But I did say, hold on, there's privileged materials in these phones. And I wasn't certain exactly everything that it was. And my first concern was these source materials. And there is a protocol in the court. I'll give the court the citation. I don't have it right off the top of my head here. It's in my papers, but I'll give you the citation that a court needs to do a preliminary determination when there's journalist source materials raised. And I properly raised it. And I said that you know,
This was prior or it was before or after the issuance of the search warrant?
it was after the issuance of the search warrant.
After issuance of the search warrant. So a judge had previously authorized the seizure and search of the phones, right?
It's a little more complicated
One
than
thing
that.
I didn't have is the search warrant affidavit, search warrant and the affidavit in my review of the papers. Maybe it's in here somewhere in some previous filing, but it wasn't attached to any of the papers that I saw.
Okay.
So I need to get that.
All right. Couple of dates. 10/6 is when Judge O'Shea issued the warrants. 10/11 was when they were executed, and 10/13 was the dates they were searched and extracted. And we didn't know that specifically until counsel gave us the Celebrate reports, which showed that Trooper Garino searched the phones on 10/13, and I have those, and I'm going to proffer those up as an exhibit. And Judge, the first exhibit I'd offer is my first email to ADA Miller.
All right, do you have a pile of these exhibits? Just give me two.
I do, sure.
Give me the 10 exhibits that you want to introduce.
Sure. Here you go.
Okay, you got 10 exhibits. How many exhibits you got?
Thank you. It depends how you want to do them. If you want to do,
Are these in order?
somewhat, Your Honor. There's emails, then there's statements.
All right. So let me just see if there's any objection from prosecution to any of these.
None, Your Honor.
Okay. So just for the record, we have an email from Tim Brado, subject Carney, date October 19 at 3:57 p.m. We have Commonwealth representations regarding searching phones, a single-page document. We have application.
All right, watching along with you at home, here to discuss is law enforcement.
Right, let's skip through. Hold on, let me skip to the next part. There was going to be interruptions. It's just going to be how it is, but I'll skip us through. So hold on one second. All right, we're back in court.
Page document which has certain highlights on it. We have a screen share or what do you call this?
A screenshot, Your Honor.
Screenshot, thank you. It's in the middle, it says Windows cannot open the folder.
That may not be, that may not have to come up, Your Honor.
I'm sorry?
That may not come up, Your Honor. It's
All
a,
right, then we have a progress report of an extraction from Trooper Guarino. We have two of them, actually.
those are 1013, Your Honor. dated
Then we
1013.
have a copy of, looks like the same email from Tim Bradel. You don't want a duplicate copy,
I don't need a
right?
duplicate, Your Honor.
That's a duplicate.
Thank
Then
you.
we have a email from Brian Tully to Tim Bradel dated April 27, 2024, which is a multi-page document.
Actually, Your Honor, the stapled copy is a series of emails going through December 20th. This refers to my request for tainting and to cease searching, and it lays out the factual back and forth about the Commonwealth's refusal to
This is October,
cooperate.
April 27th.
I have, it's a packet that begins with October 19th, and the last page is a December 20th email.
I see, okay.
Do you have that?
Yes.
Okay. So that lays out the initial.
We'll mark these in the order I just identified them.
Sure.
Okay, and one. Looks like 1 through 7.
Thank you. So, Your Honor, at the very beginning of this case, 1019, as soon as I was retained on this case, I asked if they would agree to the appointment of a taint team on 1019. I cited the preventive medicine case in that email. Counsel, if you ask me, clearly didn't apprehend, Counsel Mello clearly didn't apprehend anything about the case law about a taint team. He, on the same day, he said he would not agree to any third-party review. That's the second email. And he said he doesn't know how far they've gotten. And we were going to go to Stoughton Court at the time. I was going to go in there with a protective order to stop any searching and ask for the taint team in light of their refusal to cooperate, even though I cited the case. And a couple quick things about preventive medicine, Your Honor, I know you're aware of it, is it puts an affirmative duty on the Commonwealth to go to Superior Court and put before the Superior Court a protocol to protect any privileged documents. And
Which privilege?
Well, that's the question, Judge.
Preventive medicine deals with attorney-client privilege.
Preventive medicine deals with attorney-client privilege. There's other privileges as well. Like I said, I'll give you the case. I just don't have it right in front of me. The case law says that when there's journalist issues, the Superior Court will do a review, a preliminary review of it.
Would be nice to have that.
Yeah, I'll get it to you. It's in my computer, Judge. I'll get that to you. But just for purposes of my argument right now, I'll just say that was on the table as well. He's a journalist. He has all this source
All of that
material.
was known to the judge who issued the warrant authorizing the search of his records, right?
I don't know, Your Honor. I don't know. I suppose so. These things are, it's the Onyx White language, Your Honor. The cell phone
The
is...
Onyx what?
The Onyx White case, Judge.
Onyx White.
There's some language out of that applies here. And the language is that, a cell phone is the file cabinet of everyone's entire life. And it's akin to, issuing a search warrant for an entire city as opposed to one residence. There needs to be a focus on the overbreadth of the warrants here, Judge.
Well, that's a different motion.
Well, I don't think it's a different motion. I think it's another privilege that I wanted to bring before the court. And so that's what I was doing at the time, was saying, hold on a second, we need to deal with this taint team issue. And at some point, it was communicated to me.
Someone said no.
At some point, it was, yes, he said no on the 19th.
Okay, and then you filed a motion for protective order or something?
I filed it in Stoughton District Court, Your Honor.
And what happened on that?
And then Attorney Mello came in and said, well, we're indicting the case anyway, and it wasn't heard in Stoughton District
So you
Court.
renewed the protective order and the Superior Court posted that.
So in Superior Court, Your Honor, at that point, the chronology is important. In November, Your Honor, that's when Attorney Mello did an about-face and said, okay, we're going to stop searching. And Attorney Mello made all sorts of vague, contradictory statements about what the status of the phones was. And those statements are in one of my...
So there's no contest that was abided by, the Commonwealth abided by that representation. That is to say, there was no searching after Mello said we're going to stop searching. The searching that you're talking about that obviously happened back in the October time.
October 13th, Your Honor.
Right?
Correct.
Before you even asked for the tainting.
Right. We had no idea that happened.
Okay.
And it was never disclosed to us. In fact, it was covered up, and we were lied to about it.
Okay.
And one of my exhibits, Judge, is 6 quotes from the Commonwealth. And just so I'm clear here, Judge, we have no beef with Attorney Cosgrove's veracity on anything. We're talking about, you know, he was brought into this thing later, and we're not saying that he participated in any cover-ups or misrepresentations. But the first 4 are all blatant lies. If you look at number 1, this is the document marked Commonwealth representations regarding searching phones. That exhibit, Your Honor, indicates number 1 at 11/28/23. Mr. Mello said, the state police and the investigators have not perused the material. It is in pristine form located on the defendant's devices. That is a complete falsehood, and we know it's a falsehood because on 10th...
I'll go back and listen to the hearing and take it in context. Okay?
Sure,
Go
right ahead. All of these are all misrepresentations,
okay.
So they've misled us as to the state of the evidence. And they not only had the search of 2 of my clients' phones...
How are you prejudiced by that?
How are we
Because
prejudiced?
it's obviously there was
Yeah.
a search. The search happened.
Yep.
You're gonna get the contents of the search, right? The extraction. Where's the prejudice?
The prejudice, Judge, so first of all, this is a suppression for unreasonable delay. My brother's going to talk about discovery issues and prejudice, but in terms of an unreasonable delay, Your Honor, this all goes to the reasonableness of the delay. But to answer your question, I know you always want to answer a judge's question when they ask you a question. And the answer is, the prejudice is that the whole reason the Commonwealth was doing this was to stop Mr. Carney's reporting. That's why they didn't want to give him back anything. They wanted to get in there. Remember, at the time, the FBI was investigating these people. They were dying to know what was in Mr. Carney's phone about the FBI investigation of these people. Mr. Carney was eating their lunch in the media, exposing them for all sorts of untoward behavior in the Karen Reed case, and they wanted to stop his reporting. They took his phones under this never before generated theory of witness intimidation. They took all of his devices, they cleaned out his house of every computer, iPad device in there, and they kept it. And it was full of his source material.
You're looking for a sanction in a criminal case that would advantage your client, unrelated to what you have described as the prejudice. The prejudice is different, the inability to report. And if he was somehow hindered in his ability to report, I would have thought that you would have petitioned for the return of the phones. Why the phones are so important, I'm not sure I know. Is there an affidavit to that effect before me?
We did petition for that, Your Honor. We asked for the phones.
When was that? Where's the motion? Where will I find a motion for return of phones?
We asked for the...
Is there a motion for the return of the phones?
I don't think we got that far, Your Honor, because we were under the...
Okay, so now the next question. Is there an affidavit describing the prejudice that you described?
Judge, the prejudice is that a journalist has had the tools of his trade taken from him, and every single day he cannot access the tools of his trade. That's the prejudice.
If somebody takes my phone, I go to the Apple store the next day, buy a new phone, and I'm up and running. Right? There's no problem with that.
No. He couldn't do that, Your Honor.
So that's why I'm asking for an affidavit. Okay? And I don't have an affidavit from you, right?
Judge, you know, we have provided so much to the Commonwealth, asking for the phones back. We were under the impression they were not searched yet. You know, you got to remember that we were under the impression they were not searched yet. So there was So we wanted either a mirror image of the devices or the devices back, because that's what the Commonwealth does in these cases, is they have the ability to give the phones back. There's no issue with the fact that the Commonwealth can take a mirror image of a device and then return the devices. In the series of emails, Attorney Mello said, no, we're not returning the devices, we're not giving anything back. And Judge, and also in terms of the items in the phone, Judge, it's not just the journalistic tools of his trade, it's that we needed to use the phones to defend Mr. Carney against these allegations. They're looking for evidence of these supposed instances of witness intimidation. We need to look at them and push back and look at the phones to defend Mr. Carney. I mean, it's not just the journalism issue. It's that this is evidence that we still, to this day, 11 and a half months later, we still don't have. We still don't have it. So this motion that I'm before the court on is focused on unreasonable delay, not prejudice, unreasonable delay. And so, but there is prejudice, and I think I answered you that we can't defend Mr. Carney, he can't do his job, and these people are the targets of Mr. Carney's. This goes to the conflict of interest that's been throughout this case all along, Your Honor, is that these are the very investigators that are supposed victims in these 16 indictments in the 23 case, and yet they're still the investigators on the case. And they're targets of Mr. Carney's reporting. Mr. Carney's reporting is in his devices, and they go steal his devices. This thing stinks, Your Honor. So Mello delays the first month into late November of a year ago, Your Honor, saying no tainting.
Let me just focus you on the law for a second.
Sure.
Okay.
All right, in case you're wondering, this is being held in the smaller court.
All right, we're going to skip through. I'll be right back with us back in court. Hold on. And here we are.
The Commonwealth submitted an opposition that describes at length that the cases that you recite and rely on are not cases where a warrant was authorized for the seizure of the device, the search of the device. And here we have that situation. Are you referring me to any cases that deal with the timeliness of the search when authorized by a prior warrant?
I anticipated you would be concerned about that issue, Your Honor. Here's my answer. There are no cases, no appellate cases in Massachusetts. I couldn't find a case across the country where a investigative team had a warrant and then sat on it, didn't disclose anything to the defense for over a year, and was suppressed for unreasonable delay. There's no case where an investigative team did that. I think that's probably a good thing. This is an anomaly that, in this case, the investigative team got a search warrant, searched 2 of the devices, lied about it, kept it from us for almost a year, and then sat on it and didn't share any of the stuff with us, and pretended that they didn't search the devices to us until 9 months ago.
Is there a trial date in this case?
No, Your Honor.
Usually delayed disclosure is assessed against the prejudice to one party or another. And here we don't even have a trial date yet. So obviously this stuff is going to be disclosed ASAP, right? Whatever was imaged and extracted from phones in October is going to be disclosed ASAP.
Well, I appreciate
we're going to talk about a schedule for that.
Sure, I appreciate that, Your Honor, but that's too little too late as far as we're concerned.
And obviously, if there's going to be a search of the other devices, there's going to need to be a tainting at least to evaluate your argument that there is attorney-client privilege material on the phone, on the devices, right? That's going to have to be resolved, and that's going to have to be done on an expedited basis.
Yes, Your
Okay?
Honor.
But I am hard-pressed to understand the basis for your suppression motion.
Here, Judge, let me talk about the unreasonable delay. It's cited in my brother's memorandum, and it's the bedrock principle is that reasonableness is the touchstone of every search. Reasonableness. Unreasonable delay, the case law talks about, all the cases talk about when a phone is seized without a warrant, but the delay in getting the warrant. And that delay is never there's some outlier cases where it's a few months that they allow it. But the most of the case law, and it's all cited in my brief, is that it's 2 weeks, 3 weeks, a month. That's it to get the warrant and get the search to go.
Right, without a judicial approval.
Yes.
Grabbing something that belongs to somebody else, seizing it,
Right.
and hanging on to it for investigative purposes, you need a judge to say that's okay. And essentially, that's what happened.
Yes.
Right? The judge said it's okay to seize these devices from Mr. Carter.
Yes. But where reasonableness is the touchstone of every search, reasonableness still applies. And reasonableness doesn't allow the Commonwealth, in this case or any other case, to sit on evidence and deprive us of evidence for over a year. How much they searched it, they've obfuscated it all over the place. At the time, we were under the impression nothing was searched. And then Attorney Bettero's letter of 1017, Your Honor, that you referred to, that's around the time when we first realized, not from the Commonwealth, from a whistleblower from the Stoughton court who supplied us with an extraction dated 1013. That's how we learned that the devices were searched. Up until that point.
You hear that, guys? A whistleblower recently divulged the information that there was a burner phone, that there were these communications going on, that his phone was even searched. They didn't know this. All this stuff is going on and being kept from Turtleboy.
Even Mr. Cosgrove was in the dark about that these were searched. Mello lied about it. He knew about it 100% because he authorized, according to Tully's testimony, he authorized the extraction to go to the Stoughton court back in October of 23. So there's no question that Mello knew about this. Still didn't disclose it and misrepresented to the court that these phones were not searched. So we were misled as to the fact that they were searched.
Right.
If we knew they were searched...
I think I understand your argument. I should hear from Mr. Cosgrove on the issue of motion to suppress, and then I'll hear on the 1417 motion.
My last point, Judge, if I may, is that reasonableness doesn't go away. And the fact that they got a warrant and then did nothing for a year, that has to implicate reasonableness, Your Honor. And it is, if you use the warrantless cases as a yardstick, this amount of time, Your Honor, is insanely beyond the pale and was done for an ulterior motive of violating Mr. Carney's civil rights and depriving him of the ability to start defending himself. Thank you, Your Honor.
Your Honor, for the record, Exhibits 1 through 7 have been marked.
Thank you.
I will be brief, Your Honor, and confine my remarks to just a couple of comments. I don't take from Your Honor's questions to my brother that you necessarily have made any decision about my arguments, but I do take from your questions that you've read my memorandum and understand the essential points that the Commonwealth has sought to make, chief of which is that at least 6 days before Mr. Bradel came into the case, and before he made any request in terms of setting up a taint team, and even then made no mention of attorney-client privilege, the phone had already been searched. It had been downloaded. Lieutenant Tully had looked at it. Attorney Mello has not looked at the extraction report. I have not looked at the extraction report. But certainly in terms of purposes of the law of search and seizure, once the phone extraction is made and once the report was perused, certainly by the time the report was perused by Lieutenant Tully, it had been legally completely searched. So from my point of view, whatever the reasoning was back at the time, whether Attorney Mello didn't quite understand the significance of the Cellbrite report, or for whatever reason, I don't understand, frankly, why there would be any purpose at that point to have a tainting after the cat was out of the bag with respect to those items. There certainly would be a purpose at whatever point Attorney Bradel represented to Attorney Mello that there was privileged attorney-client privilege material. In stopping any further search, we still had, I think it's 4 additional cell phones, the exact number escapes me, that were found in Mr. Kearney's closet, and we still had a laptop computer and some other paraphernalia that had not been searched. Mr. Mello's initial representation to Mr. Kearney that the Commonwealth would cease further search, I think, was precisely accurate. I think some of his later statements are fairly susceptible to interpretation. He seemed to go back and forth between saying, we'll cease further search, or the devices have not been searched. And even that statement is true if you're talking about all of the remaining devices other than the 2 cell phones that were searched. I emphasize that there has been no harm to the defendant. He has plenty of time to examine the Cellbrite reports. I have yet to look at them, and I represented in my memorandum that I would not do so until he had a chance to bring the issue before this court. But I have here on a thumb drive both of the Cellbrite reports, and there's no need to set a deadline for the Commonwealth to turn that over, Your Honor, because I'm going to hand it to Mr. Bedrow right now, and I'm pretty confident that he will share those with Mr. Bradel, and they can go through those reports to their heart's content.
I'm muted, sorry. So he has some flash drives of some reports handed over to him, the extractions basically from Carney's cell phone, and he does get his phone back as well.
And if there's any privilege material, whether it's a reporter privilege or attorney-client privilege, although as noted, Lieutenant Tully did not find any.
All right, here to discuss.
All right, let me pause and get us right back to court. Hold on. All right, well, on second thought, that was it. They cut it off. They did not give us the rest of the hearing, unfortunately, but that's pretty much how it ended. They did some scheduling. They're going to come back in December to discuss any, well, no, this is December, so they're coming back later this month. I think it's the 17th they rescheduled, or they had another hearing where they're going to discuss any outstanding discovery. The judge did order over Morrissey's emails, or did Cosgrove just willingly give them over? I'm not even sure at this point, but why Cosgrove was so, anti giving them anything at first, and then all of a sudden now, after these Betterow letters and everything that's come out, he seems to be cooperating somewhat, it seems. He gave him flash drives with Cellbrite reports of his cell phone. They gave him his cell phone back. They still have laptop, tablets, and a couple other phones, but at least they gave him his personal cell phone back. And then, what else was I going to say? They gave him his phone back. They gave him flash drives, and they're going to give him. They're going to turn over the Michael Morrissey email discovery, whatever is relevant. It's going to get to them eventually. So they're working on that, and then they're going to meet again December 17th, I think it was, to go over any outstanding discovery and any more motions that might come along. So that is what is happening in the Turtleboy case. So hopefully he gets some Michael Morrissey emails that can really help his case there and maybe even help Karen Reed's case, which would be awesome. Um, I would not be surprised at this point in time if there are flat out emails, Michael Morrissey saying, Bev, do not let her get acquitted. But that's just my humble opinion. But I don't think very highly of these people in Massachusetts. At least the people who are supposed to be upholding the law, uh, like the DA and the judges. All right, so that is it for today. I'm sure there will be more news in the Karen Reed front shortly, so I will see you guys then. Be sure to be subscribed, and please, if you don't mind, hit that like button for me on the way out, and I will see you guys.